He's sitting there just smoking. He's like disoriented completely.
When the police respond to reports of a wrong-way driver and arrive on scene, finding my client parked in the travel lane, facing the wrong direction, disoriented, and later admitted to drinking, it seems like a slam-dunk DUI case.
He's not looking at me at all.
Yo, what's going on, man? You all right?
We're going to use this real-world incident to dive deep into a narrow subset of Florida law, focusing on the legal authority of a police officer to make a warrantless arrest in a misdemeanor case. That's a lot. Let's dive in.
You can lower the window for me.
In this video, you can expect to watch the relevant portions of the officer's body camera footage. You'll hear the officer testify under oath, answering my questions in a motion to suppress. And finally, at the end, I will take the prosecution side of the case and I will push back a little bit differently on the judge's opinion. Thank you in advance for continuing the discussion in the comments down below so we can all become better informed citizens together. From a Fourth Amendment legal analysis standpoint, our situation is just a simple traffic stop. To be valid, an officer has to have reasonable articulable suspicion of a traffic violation, a criminal violation, or some sort of medical emergency in order to justify a traffic stop. We have that here, no problem. He's facing the wrong direction in the travel lane. To prolong that detention to a DUI investigation, the officer has to have additional belief that the person is impaired. I think our body camera footage here shows objectively that the police officers had reasonable articulable suspicion to believe that my client was impaired or to believe there was some type of medical emergency going on. Either way, the detention for further investigation is warranted. The primary deputy returned to his patrol car, ran the defendant's driver's license to the various government databases, and then made a phone call requesting a DUI officer respond to the scene to conduct a DUI investigation.
You want a DUI?
It is important to the legal analysis to know that after this phone call, there was no additional communication between the officers until after the DUI investigation began. We've already established that the officers have satisfied the legal threshold of reasonable suspicion to detain someone for a DUI investigation in this case. Because it's important, let's briefly dive into what reasonable articulable suspicion actually means. In the Florida Police Academy Manual, which is authored by the Florida Criminal Justice Standards and Training Commission, it explains reasonable suspicion like this. Reasonable suspicion means you can articulate or put into words facts that support a suspicion that a person stopped may be involved in a law violation. The facts and circumstances must support the suspicion that the person committed a crime, is committing a crime, or is about to commit a crime. Reasonable suspicion may be established through a number of sources such as personal observation, information from fellow officers, information from third parties such as informants, and BOLOs. This means that reasonable articulable suspicion is a very low standard. I've used this graphic representation to explain this concept in the police academy. Because this burden is so low, officers can satisfy the legal requirement with just a few articulated suspicion. Turning back to the case at hand, critical to getting my client's case dismissed is the fact that reasonable articulable suspicion applies to all elements of the offense. So in addition to articulating impairment, the officers also have to be able to articulate how they knew the person was driving the car. Identifying the driver generally doesn't become an issue on traffic stops. Usually the officer witnesses everything. This is normally an issue in traffic accident scenarios where the officer responds after the fact.
Driving that way, the wrong way in the road.
I don't remember.
You don't remember? Okay. So, based on what we observed, and then just from talking to you, I have reason to believe that you may be impaired past the legal limit. Would you be willing to do exercises to see where you are?
See, I can barely stand up right now.
Okay. So you don't want to do the exercises? No? Okay. So understand, if you don't do the exercises, we have to make an arrest decision based on...
Do whatever the hell you want.
Okay. So you understand that if you don't do the exercises, we have to make an arrest decision based on what we have observed? Okay. Gotcha. All right. Put your hands behind your back.
The officer just arrested my client for DUI, but he doesn't have a warrant. How can that be possible when the Fourth Amendment protects us from unreasonable search and seizures without a warrant supported by probable cause. On first read of the Fourth Amendment, you might think that a person cannot be arrested without a warrant, but you're missing out on the carve-out made by the founding forefathers that allowed for reasonable searches and seizures. This allows the legislative branch and the judicial branch to carve out exceptions for the executive branch, police officers, to act upon. The rule I teach the recruits at the academy is that the default is you need a warrant. If you don't have a warrant, you have to be able to point to a specific legal exception. These exceptions are enumerated under Florida State Statute 901.15. To be arrested for a misdemeanor offense in Florida, the law requires that all elements to have occurred within the presence of the officer or that another exception applies. There's two ways the police can circumvent this didn't occur in my presence problem. The state legislature enumerated a list of offenses. If the offense the officer is investigating is on that list, they only need probable cause to believe the defendant committed the violation. DUI is not on that list. And while not exactly an exception, there's a judicial theory called the fellow officer rule that says Officer 2 can rely on the observations and information known to Officer 1 as if it were his own. So as long as Officer 1 makes some observations and communicates the information to Officer 2, the exception applies.
Once you arrived on scene, I guess you activate your body cameras, probably policy of the sheriff's office, correct?
Yes, sir.
So what we saw here is a few minutes after you got on scene?
It should be right when I got on scene.
Okay, so right when you got on scene, and then he was either just coming out of the back of the ambulance or was just outside the ambulance, just been pulled out of the ambulance. Is that accurate?
Yeah, outside the ambulance, yes.
Up to that point in time, you got a phone call from Deputy Geller, correct?
Yes, sir.
I believe he said, hey, I got a DUI, do you want it?
Yes, sir.
Something like that?
Something like that, yeah.
And then I think when you were on the computer, on the video, it shows that you were probably looking him up on David?
Yes, sir. Yeah, it was David.
I believe that was David, right? Mm-hmm. So you probably get that from the call notes?
Yeah, I think it had the license plate number in the call.
Okay, and so and when we say call notes, we're talking about CAD notes. Can you briefly describe what CAD notes are?
Yeah, so when we receive a call for service, 911 call taker gets it, they set the call up, and then it gets dispatched to us. And it just has brief descriptions that the 911 call taker inputs from the caller.
And when you approached, you engaged in a conversation with him, did you suspect that he was impaired already?
I had like a inkling.
In our case, the officer was summoned to the scene by phone call. During that phone call, he was not provided with sufficient information to identify the driver. When he arrived on scene, he reviewed the call notes, ran the information through the database, and generated his own investigation assumptions without an initial briefing from the police officer. That's a problem for the fellow officer rule. Let's listen to the judge explain it.
The argument from the defense does not require the court to determine probable cause for the arrest. Is simply whether there is a reasonable suspicion for Deputy Linton to conduct a DUI investigation. The fellow officer rule does create a bridge between the officers. It's unnecessary for all the officers to see all of the things. The fellow officer rule permits an officer that makes an observation of some of the elements to communicate what that officer observed to the other officer, so the officer can then pick up the investigation. The argument the defense has made is that there was no connection or bridge between the observations and testimony of Deputy Geller and the observations and testimony of Deputy Linton. There does not appear to be any bridge between those two communications that would provide the arresting officer, that be Deputy Linton, with the information necessary to establish that one of the elements of the defendant was operating a motor vehicle. Deputy Linton never saw the defendant behind the wheel, and Deputy Geller never communicated to Deputy Linton the observations that he made regarding the defendant behind the wheel and the observations shortly after he got out of the vehicle. Had Deputy Geller and Deputy Linton had an opportunity to speak at the scene for just a few moments, it might be a different outcome from the standpoint that I would then have to address whether there was reasonable suspicion to conduct the DUI investigation based upon that shared knowledge, or whether the findings or observations of Deputy Linton were sufficient probable cause for the arrest the court doesn't need to reach that because I'm finding that there was no reasonable suspicion for the investigation based upon failure to communicate that information observed by Deputy Geller to Deputy Linton. And so I'm going to grant the motion to suppress.
The prosecution didn't argue the original radio communication. The officers were arriving on scene, describing what was going on over the radio. They also said we got one male in the vehicle, dazed and disoriented, and requested EMS respond, I believe. He then communicated he wanted DUI. You also have the body language after the fact when the officer arrived on scene. They didn't stop him. They kind of, didn't say anything, but it was kind of a transition there. So there was body language and positioning that could be applied. If you take all of those factors into consideration, I think there might be reasonable articulable suspicion to believe that he's the driver. But we're still going to have the problem with probable cause. I don't think it rises to that level. If we go to a house on a domestic violence call and there is a person there, but there's nothing communicated and you see a slap mark on the face, I don't think that's enough. But if you get that same person to write a statement and say, John hit me, that is going to be enough, even with no mark. Probable cause requires reasonably prudent man to look at this. And I think a reasonably prudent man confirms, is that the guy driving before he takes over?